Good evening, everyone. Welcome to Rights at Night. This is our monthly sessions that we do to learn more about our legal rights here as educators in Georgia. Thank you all for joining us this evening. I am Lisa Morgan. I am a kindergarten teacher in DeKalb County and currently serving as GAE president. So we're all glad you're with us this evening. I would ask you, as we're in the presentation, if you have questions, if you'll please put those in the chat, and then we will, I'll call on you to ask your question. You can just put question in the chat. So we can kind of keep it moving and keep us in some kind of order since we are virtual. But I would like to thank you all for joining us, and I'm going to introduce, we have two people here with us this evening who are going to be giving us all our great information. First, Ms. Taya Donald is a UNICEF director for GAE, and she currently works with DeKalb County and the city of Decatur. And our general counsel, Mike McGonigal, is our general counsel, and he's going to start us off. So, Mike.
Thanks, Lisa. Good evening, everybody. Let me share my slides from the beginning. Can everybody see that okay or not?
The slideshow disappeared, Mike. You might want to hit from the beginning again.
Oh my. Well, let's see.
I can see it just fine.
Okay.
You can see it just fine?
Yep.
Yeah.
And we're getting some thumbs up, so I think we're okay.
All right. Okay. Well, it's not displaying the best on my screen, but I'm trying to change that if I can. Can we still see it?
Hmm?
All right. Okay.
Yes.
All right. Sorry for that. So we're going to cover tonight. Again, I apologize. I have two screens here. Did it advance or not?
No.
No. Okay. Let me try it. Hit from the beginning again. Did not advance. No, didn't advance.
Nope.
Okay.
Hold on.
Mr. Mike, you may want to hit the hourglass. Did you want to do it that way? Hit the hourglass in the bottom right-hand corner? Well, it looks like a little wine cup or something.
Well, I'll click the bottom.
Not that.
Not
Go
that.
up, go over. Okay. Go over to the left. Yeah, right there. You just passed it. It looks like a wine glass with a minus in it. Yes.
It's not doing it.
Hmm.
Mike, you want me to try?
If you don't mind, it doesn't
Yep.
seem to be working out too well right now.
Okay, I've got it. Share screen. Yes. Oh. Okay, there you go.
There we go. All right, just a few warm-up slides, just a reminder to everybody, you know who we are. We stand up for all education employees, classroom educators, school bus drivers, lunchroom workers, administration. I like to remind people, we are also the product in the 1970s of a merger of the Black Educator Association and the White Education Association after the days of Jim Crow were officially over. And the values of the merger that we stand by are equality, democracy, and inclusion for all people. And I see GAE as an institution that follows those values, and that we attempt to instill those values in our members in their professional lives. Next slide. There we go. Well, I have a captive audience, and I always want to plug legal services and what we offer in comparison to other organizations. We have up to $3 million aggregate liability protection, which is more than our competitors. The same is true with the attorney's fees that we would cover through a liability lawsuit action against our members. But employment liability is not really accessed too often. We don't really have that many lawsuits filed against members per year, maybe 4 or 5 or 6 or something along those lines. And you never, of course, if you have that protection, I mean, we offer that protection, it's there if you need it. But the bulk of our work comes in the employment defense and certification defense. And where we really exceed the competition is that we have no predetermined cap on the amount of legal fees and expenses that we will put into a legal case, whether it's in the defense realm or an affirmative lawsuit. And that is the other distinction that makes us unique and different and better, provides better value, is that we file lawsuits against school districts, such as our COVID reopening lawsuit that we have currently pending in Fulton County Superior Court, which, you know, we're still waiting on the court to make a decision in that particular case. But no other organization has the financial resources to file a lawsuit like that, especially one of that magnitude. We've been in existence over 50 years, expended millions of dollars in defense of members' rights, as well as to expand member rights. So we appreciate your membership. Next slide, Lisa. So the goals, just generally speaking, it's going to be a general overview. If you have questions about particular employment matters that are affecting you individually, I'd have to address those at a very high level. And of course, I'd speak to you offline, or you should contact your UniServe director with individual specific circumstances. But what I want to go through tonight is something that's called right to work. I want to explore what right to work means, what at-will employment is, what that means. And when we want to get into this area of employment rights for our members in Georgia, we always have to remind ourselves about waiver of state education laws. I'm going to hit on a few sources of laws. Those are some tools you can use. A couple of state statutes, which are very important to advocacy and organizing in our local associations, the Open Records Act and Open Meetings Act. And then I'll touch upon some federal employment laws. And if time permits, we'll get into First Amendment rights and social media. And we want to reserve time towards the end to some more real practical what to do in certain situations through our UniServe director, Taya Donnell. And so we'll, wherever I'm at, maybe say with about 10 minutes left, we really want to turn it over to Taya for her insight and comments and information. So right to work is often asked, so is Georgia a right to work state? And the short answer is yes, we're a right to work state, but what does that really mean? And so it means that you cannot be compelled to join a union as a condition of employment. And that term right to work is infused with the rhetoric of an individual's freedom to decide. That is how the ideology of freedom and choice is structured to keep the labor force in Georgia divided and suppressed. And this law came up during the Jim Crow era in 1947. It's part of a broader set of laws that was designed to perpetuate segregationist attitudes in this state, to divide the labor force, to keep it divided amongst themselves. And so without, compulsory union dues like we have in other states, we're divided amongst ourselves. And that is exactly how school districts want us and how the labor landscape is structured here in Georgia. And I came across, there's a good article, and I quoted at the bottom, written by the Lerner Center for Public Health Promotion at Syracuse University, that looks at the COVID-19 situation and discusses COVID-19 in the context of labor rights in Georgia. And the authors come up with the quote I put there, that we're in an impossible situation, that we're merely the latest victims in a series of labor abuses. And what the article talks about is how the pandemic has exposed structural inequities throughout, our school systems, so throughout our society. And a part of our lawsuit is to get the government to do the right thing to protect its employees by mandating masks, mandating social distancing, and mandating enforcement when those things don't occur. And so the COVID, again, presents structural inequities that still exist, and we must continue to speak up and out loudly about those inequities as we, forge ahead into 2022, certainly in this Georgia legislative session. Next slide. So right to work, again, means it's a very simple proposition that you cannot be compelled to join a union as a term and condition of employment. It's a simple proposition. But does that mean we cannot form a traditional union? Or we take a popular misconception. So in Georgia, does that mean, since we're right to work, does that mean we cannot bargain? And the answer is yes, we can bargain. And the fact is, we bargain all the time. Like if you bought a house, you probably bargained over the price. If you bought a car, you've bargained and negotiated over the price of that automobile. So bargaining and negotiation is an everyday fact of life that continues to go on even though we are right to work. And it's something that, it's another value of bargaining and negotiating that we need to instill in our members and make them aware that just because we don't have traditional union rights and traditional collective bargaining, we bargain all the time. And we do have a right to say, go to the superintendent or HR or the school board and express our views to the school board and pressure them to adopt policies that need adopting at the local level. So it's a popular misconception that we cannot bargain because we're a right to work state. It's also, in my view, a popular misconception because I see this quote from Title 20. Title 20 is the state education law. And there's a section, a very minor section that says nothing in this part shall be construed to permit or foster collective bargaining. Well, that sentence is buried at the end of what they call the state's complaint statute or the grievance statute. So it really has never been interpreted by Georgia's courts. You know, what does that mean, especially in the context of the state grievance statute? My opinion is it really has no, it doesn't, it's so limited, that language is so limiting that we are free, if we have the numbers at the local level and we elect school board members, we can engage in have a collectively bargained agreement with a local board of education. But that's going to take, you know, over 50% membership in a local, and electing school board members that agree with the concept of a collectively bargained contract for you. Now, the Chatham case that I quote, also, it's an old case, but it stood for the proposition that the Chatham School Board could not delegate the purchase of a benefit. It was health insurance for school system employees. They said that Georgia Supreme Court said that the school board did not have the authority to delegate, didn't have the authority to delegate that to a third party. Well, the problem with that decision is that we school boards delegate to third parties all the time. We privatize custodians, we privatize bus drivers. We have private companies that actually bring in teachers on a private basis, a placement organization to teach our children. Well, that's certainly a delegation of authority to a third party to conduct school business. So it is a popular misconception that we can't collectively bargain. And even if that interpretation doesn't hold enough water for you, then we can pass enabling legislation at the state level. The state legislature can adopt a statute that says public school employees, you know, shall have the right to engage in collective bargaining in Georgia. Simple sentence, that's enabling legislation. How soon are we going to get to that, you know, the promised land of collective bargaining through enabling legislation is anybody's guess. But that is the other avenue we can take to form traditional unions with our local school boards of education. So obviously who we elect matters more than ever. So next, yeah, right to work. Thanks, Lisa. What does it mean? And so it really means, it does boil down to, you can't be compelled to join a union in a public employment. I will put this as a footnote: firefighters and police officers can form unions, but not public school teachers. So you don't have state level job protections in Georgia, unfortunately. But if you, regardless of your job classification, whether you're a classified employee or a professional employee, we then look to our federal statutory regime, whether we're looking at federal anti-discrimination law, Title VII, or we look at the Family and Medical Leave Act, the First Amendment, free speech and association, or we look at the wage and hour laws, the Fair Labor Standards Act, which basically covers really two things: minimum wage and overtime. And we'll hit on those federal laws a little bit later in the presentation. So related to right to work, remember, right to work just means you can't be compelled to join a traditional union in the workplace. Okay, well then what is at-will employment? Well, that's slightly different in the sense that it says you can be fired for a good reason, a bad reason, or for no reason at all. In the example, you know, I don't want to say it's common, but you can be fired for a good reason, like chronic tardiness, or a bad reason. And the reason for your tardiness, you were late, well, you're dropping your children off at daycare or something like that. That's unfortunately childcare, and being a parent is not protected activity. Now, if your children are sick, you might be able to find some protection, say, under the Family and Medical Leave Act for intermittent leave for taking care of a sick child. But dropping your kids off at daycare and being late would provide grounds, bad grounds, but legal grounds, not ethical grounds, not moral grounds, to terminate employment. So, and I just throw in this quote from a case where a plaintiff's employment is terminable at will, the employer cannot be held liable for wrongful discharge regardless of motives, regardless of motives. So that's a pretty strong statement. That's a big, big hill to climb under the at-will employment doctrine. And we'll see what kind of exceptions we might have from that in Georgia. Next slide. So just a little bit more history. Where does that at-will employment doctrine, where does that originate from? And when I say doctrine, that is a courts develop doctrines through its decision-making and the authorities and powers it has in the state court system. So, and it can be traced straight back to the days of slavery here in Georgia. And there's the case, 1853 case was the first case in Georgia written by the Georgia Supreme Court that laid out the at-will employment doctrine. And it has stayed with us ever since. And you can read what the case is about real brief, and you can Google the case and read it for yourself. But Henderson was a plantation overseer, and he thought Stiles, the plantation owner, owed him money, wages. And the court said, well, because nothing was in writing, he didn't get anything as a remedy because he was hired at will. And I just find that just an interesting, if not fascinating, footnote for those of us when we think about what's happening in present day contemporary society, things that have happened back a century or more are with us today. So those who would argue that the history is past and has no impact today can be refuted very easily. And I'd recommend, again, there's an article, Exploding the Original Myth Regarding Employment at Will and the True Origins of the Doctrine, written by a Professor Ballum in the Berkeley Journal of Employment and Labor Law. Next slide. So now the doctrine, the judicial doctrine, was codified by the Georgia legislature in 1910. 1910, you know, again, Jim Crow was in full force, and part of the motivation for codifying, again, the at-will doctrine, just like right to work, is to keep the labor force systematically divided by race. And what I mean by that is that Black Americans were already disadvantaged through, historical circumstances, but these statutes put it even deepen those values in place. Once the legislature puts them in the Georgia codes, they're there. And that statute is there, still there. And I quote the statute, what it says about at-will employment, and you can look up the code section, Official Code of Georgia Annotated 34-7-1, and that codifies that at-will employment doctrine. And unfortunately, Georgia courts have not recognized any exception to the at-will employment doctrine. None whatsoever. They keep punting the ball to the legislature by saying, well, hey, the legislature codified the doctrine in Title 34, so it's up to the legislature to create the exceptions. So the courts punt it back to the legislature, and we're really, again, got to instruct our members. Our members are politically active, but we have to be more politically active if we're going to get any headway and any progress in getting exceptions to the at-will employment doctrine. And the next slide will, I think, just briefly touch on what the exceptions are. No, I apologize for that. That's okay. So when we're looking at the employment rights landscape in Georgia, any presentation I do, it always has to include a slide about waivers. And when I take calls, or Taya takes calls, or UNISERV directors take calls, one of the first things we have to do is say, well, is your system a traditional model? Or are they a strategic waiver school system? Or are you a charter school system? And those latter two, strategic waiver and charter school system, are completely, they're dangerous, because the state legislature has authorized local boards of education to waive laws that were put in place for a purpose. Like class size, right? That's an easy one. Duty-free lunch, one of my all-time favorites. I used to write letters all the time, and our UNISERV directors would easily be able to beat back the failure of a school to provide a duty-free lunch to educators who taught in K through 5. Because the intent and the purpose of the law and the statutory history was so clear as to why it was there. Because teachers need a break, especially in K through 5. But the sad reality is those who we have elected have allowed local boards to waive these all-important rights that you all fought very, very hard for to get enacted. Like the duty-free lunch was back in the early 90s. Well, that's really just out the window. And we've really got to get it back. Your local board of education can file an amendment. If they have waived it, they can unwaive it. That'd be one thing. And we can go to the state legislature and lobby them to undo a waiver. Others can address the political lay of the land. But we really have to try to undo these laws that have authorized the complete wholesale disenfranchisement of your rights illegally. They've done it legally. Now we have filed several lawsuits trying to restore due process rights in court. We initially, filed one against the city of Atlanta when they went charter system, and we were not successful in that suit. But what amazes me is that the Superior Court judge's decision copied and pasted the school board's proposed decision, and she signed it. So she was completely, I don't know, bought lock, stock, and barrel by the school system and didn't change a word of their proposed order. But that's the sort of thing that we're up against when we go into court. There are judges there who don't have our value system or are afraid to challenge the value system. But we do have one case that's still alive that we have filed against Fannin County Schools on behalf of a GA member who had acquired her fair dismissal rights and her contract was not renewed and she wasn't given any due process. They just gave her a letter. She had worked there, I believe, 17 years, and out the door she goes. So we have sued, and it has gone up and down the appellate system a couple of times. The most recent decision we have received from the Georgia Court of Appeals, they sent it back to the trial court in Fulton County where it sits tonight, but they completely gave the trial court a roadmap as to how this case should be decided. And it's very simple, that educators who had acquired fair dismissal before the school board waived them have a constitutional contract. And they also, there's a provision in the Constitution that says you cannot apply statutes retroactively, which is what they have done in Fannin County. And so the Supreme Court of Appeals wrote a very, very sympathetic order remanding the case back to the trial court. And so once we get a decision from the trial court, we'll be in much better shape, because it really appears the Court of Appeals has signaled that those who acquired fair dismissal have constitutional rights to keep it. So, whoa, I think we're going backward.
Yeah, sorry, I hit it. It
That's
should
all
be
right.
where it is now.
That's okay. So I think we're going to jump into sources of our rights, a more general overview. Federal statutes, of course, we know Anti-Discrimination, Americans with Disabilities Act, Family Medical Leave Act, things of that nature. State statutes, well, yes, except that they can be waived and they can be ignored. State Board of Education, only in Georgia, I think we're singled out as having a problem with such a problem with waiving state education laws. But the State Board of Education, again, the State Board are appointed by the governor. So obviously, again, who we elect as governor is going to influence our rights making abilities through the State Board of Education. And the Professional Standards Commission also govern your certification rules and your code of ethics. And as we all know, the PSC members are political appointees appointed by the governor. So there again, who we elect matters, and particularly with the PSC and the State Board, it's the governor. The governor has lots of authority in those areas. Okay, next slide. So the action that I'm promoting, or is at the local level, at least tonight, your school board policies. Someone calls in from Camden County, wants to file a grievance. Well, what's the policy? Where are they available? Well, they should be available at the school site, the central office, and online. And what's interesting, or unfortunately interesting, in Camden County, we cannot find the grievance policy online. So we're trying to see if there have taken it offline, but have a hard copy somewhere so as to make it harder for employees to file a grievance. That's the first thing. Or did they just simply waive it? I mean, what can you do? So these waivers are very harmful, but most school districts do have policies, and that's a huge source of our rights. Next slide. So school board policies, they cover all school employees, classified and professional. Important to know what the policy is that governs transfers or layoffs, or as I was just harping on there, the grievance or complaint policy. Some districts have very good, strong grievance policies and procedures. Others, like I was just relating in Camden County, we couldn't even find it online. So there's an issue for anybody who's listening from Camden County. That might be something that as a local organization, you might want to explore. Because if they're hiding the policy manual from you, that's an issue. That's an issue. So organize around that one. Next slide. So you can find state statutes online. That's a free site, the www.legis.state.ga.us. That takes you to the General Assembly general website, but with a couple of clicks, you can get straight into the Georgia Code, and it's free. I use it all the time. So I think the next slide we get into, excuse me, the Open Records Act. Open Records Act can be very, very, very useful for getting information or seeking information from local boards of education, financial information, your personnel file, for example. The things that are exempt in under the statute are they cannot release the home addresses, public school employees, or your personal cell numbers or home numbers, social security number, insurance, and medical information. The personnel evaluation, some districts, in Title 20, there's a statute governing your personnel evaluations. And in that statute, in Title 20, it says personnel evaluations are confidential. So there's a conflict in the law where Title 20 says they're confidential. The Open Records Act says personnel files are accessible to the public. So we can take it two different ways. Next statute. So personnel files, they include all written records, of course, maintained by the school district. But what we're finding out, excuse me, in the past few years, we file race discrimination claims against some South Georgia school districts where we have very, very strong facts of race discrimination. And before the lawyers even get involved, we help the member write an Open Records Act request requesting their personnel file, as well as electronically stored information. If you're following the case in Colquitt County of our GA member, Dr. Lehman Madison, who was non-renewed 3 days after a teacher said that she was going to lynch him, we helped him write an Open Records Act requesting for the text messages and emails of school board members, the superintendent, and HR there. And we also asked for the desegregation decree that was in effect that should be in their files, because we have discovered simply by two things, asking for text messages from school board members and the superintendent, they're going to refuse to do that, even though they are required under Georgia law. And number two, asking for the 1970s desegregation decree or order sends the school district into a panic, and they don't know how to react to that. But we've gotten court orders forcing the discovery of text messages about non-renewals or failure to promote in our cases, excuse me. So the Open Records Act, I guess the short story is it's a very powerful tool that can leverage our power and settlement when we're litigating these cases. Because the last thing a school district wants is to unearth, especially a desegregation order, and it brings up all the history of de jure segregation. That's Jim Crow, de jure segregation. And the implementation of Brown versus Board of Education, which, I mean, that has never occurred. Our school systems are as segregated, probably, now about as segregated as they were around the time of Brown versus Board of Education. And the last thing a school district wants to do, especially in South Georgia, is wanting to have a federal court or the EEOC to be looking over their shoulder and examining what those desegregation orders actually said. What I've learned and becoming more familiar with is that the desegregation orders, they did govern integration on the student population, but for our purposes, they have staff components that school districts were required and still are required to have minority affirmative action programs to have a racial balance among school district administrators, for example. And when they're not complying, we can leverage that in settlement discussions when we file these sorts of lawsuits. So, all right, next slide. And so if you have a write-up, you can always attach a statement to the write-up. There is no right to have the write-up removed from your personnel file. That's another right that we have to enact either at the local level or through the Georgia legislature, a right of removal of an evaluative write-up, whatever that may be. But in the meantime, we help members write rebuttals or explanations in response to the write-up and ensure that they are stapled or affixed to the write-up. And don't be fooled, there's no time limit or statute of limitations on responding to I suppose what I would call a garden variety write-up. So even if you discover it, principal brings it to your attention when you're being evaluated at the end of the year, hey, I have a write-up of you in September. It's shocking. They should have brought it to your attention immediately, but something that happened in September brought to your attention in March or April can still be responded to. You do have that right. So the next law is, I'll just be brief, is the open meetings law. Again, it's very powerful because it gives us the ability to express our rights and how we wish to see the work environment change and develop and expand our rights is through Georgia's open meeting law. And that statute gives us rights, it gives us protections against retaliation. The only thing that there's a limitation on is that it protects along First Amendment lines, matters of public concern. I can't get to the microphone and complain about my evaluation. They can say, no, Mike, that's a personnel matter. You can't talk about that in an open session. But I can talk about, say, the lack of masks or the lack of PPE, or what are we going to do about the bus driver shortage, or what are we going to do about the cleanliness at schools, the teacher shortage. We can talk about all those things all day and all night, and we are protected under the open meetings law on that. So our next federal statute, I'll just touch on it, is the Family and Medical Leave Act. There is a limitation. You must have worked for the school district at least a year. But once you acquire that right, you're guaranteed up to 12 work weeks per year of protected leave to care for your own serious health condition or the serious health condition of an immediate family member, children, or your elderly parents. It's defined in the statute as what constitutes an immediate family member. And the good thing about the law is that they have to keep your job available, or a job that's substantially similar position, and maintain health insurance while you're out. Now, the downside of the law, where it doesn't go far enough, is that while you're out, you may be responsible for that health insurance premium. And we all know that's not cheap. It also gives the district discretion, just way too much discretion, as to whether your FMLA is going to be paid or unpaid. So it's a statute that has a lot of positives to it. It really does not go far enough, but that's a federal law that we need to lobby our congressmen and US senators to expand upon. And our next statute is the Americans with Disabilities Act. And briefly, the district has to engage in good faith discussions with you. They simply can't ignore you or drag things out, as we've seen in school districts across the state. Somebody puts in a request for an accommodation. I have high blood pressure. I need certain accommodations. And the district doesn't get back to you in a week or 2 weeks or 3 weeks or a month. Well, that's not legal. That's not legal. That doesn't demonstrate good faith. They have to demonstrate good faith. Now, whatever accommodations I'm requesting, the law says you have to attempt the accommodation at the work site first. And those accommodations in the era that we're in can be masks, respirators, isolation, social distancing, things like that, or distance learning. But the distance learning is fairly limited in a lot of counties. And it is a policy decision that is dictated by, again, who we elect at the local board level. If they want, if they open the school back up, in-person learning, despite the scientific evidence to the contrary that we shouldn't be, that puts us in a very difficult situation. It really does. And they wonder why we're experiencing a teacher shortage, a bus driver shortage, a shortage in lunchroom workers all across the board. It's because the local districts are elected to keep, make these decisions political, and it makes the accommodations request even more tragic, I would say, because the law also makes clear that the accommodation is not my wish list or my demand list. And as long as the employer is attempting accommodations at the work site, they're going to be halfway home to being found legal if they don't say they grant distance learning or teleworking as an accommodation. And leave can be an accommodation as well. But it has to be of a short duration. Courts have said leave as an accommodation under the ADA is really maybe only a few days, a week at the very, very most. Courts aren't very generous interpreting the ADA up to this point in the cases that I've read. And so our next slide gets to First Amendment protections. And it really, just to impress on everybody, obviously it's not absolute. It doesn't give us the right to say what we want, wherever we want, to whomever we want. Next slide. So the general idea behind the First Amendment is your greatest protection is when you're speaking as a private citizen on a matter of public concern, like we talked about in the open meetings law situation. If I get up to the microphone and complain about my evaluation, that's not a matter of public concern. The taxpayers of wherever I'm talking, they aren't going to care about my evaluation, but they're going to care about the lack of safety, the lack of masking, the lack of, you name it, or salary or class size. And when you speak at a school board meeting, always use your other statuses to emphasize you're there as a private citizen. I'm a taxpayer, I'm a voter, I'm a parent. Those things are going to layer more protection on your speech and protects you from retaliation from the school district. Next slide. There's a lot of things going on in this statute. The United States Supreme Court in 2006 came out with a very anti-public employee speech case where this Ceballos was a district attorney in California. He was fired for blowing the whistle on a ticket fixing scheme in the police department. And Garcetti was the police chief at the time. And Ceballos fired saying that the First Amendment protected his speech. He was blowing the whistle on illegal activities in the police department. And the United States Supreme Court said, no, you don't have a constitutional right to do something that you're supposed to do if it's in your job duty. So if I'm a school employee, I'm a mandated child abuse reporter, and I get fired for reporting child abuse, I can sue them, but I'm probably not going to prevail on a First Amendment claim because it's my job and my duty to report child abuse. Now, I might prevail on a state whistleblower claim, or if I'm advocating for special needs children, I might have a claim under the Americans with Disabilities Act for advocating on behalf of disabled children, or I might have a claim under Section 504 or IDEA, but not under the US Constitution. So, got to stick with our strongest protections, speaking as a private citizen, matters of public concern. But even if I do that, this Atwater case says if my speech causes a disruption, my speech may not be protected. And the next slide will touch upon what the court said in that particular case. And so what happened in 2015, in that range, there was a Christmas parade in Tifton, and there was a Black Lives Matter march going on at the same time, and a teacher at the Tift County Middle School went online and started saying some pretty disgusting and racist things about the marchers, such as take the hood off your head. And I think she meant take the hoodie, but she said hood. Pull up your dang pants and quit impregnating everybody. I'm sorry for these blankety blank thugs. And she goes on. Well, can you imagine? Now that might be a matter of public concern, but can you imagine the impact that her social media post had on the kids at Tift County schools, at middle school, or the parents of those students at the middle school that were assigned to Ms. Tucker? So it created, she may have been hitting upon a matter of public concern, but it was offensive and disruptive to the school. And it harmed these kids to hear their teacher talking about their identity in such a derogatory and insulting way. So she filed her First Amendment lawsuit, and the court, avoiding all the legal jargon, they dismissed it, saying that it disrupted the school so much that her speech was not protected. And I think we can hit on maybe just this, let's just do this and then maybe turn it over to Taya for some final remarks.
Okay.
Or what do you want to do?
Okay, Mike, I want to jump ahead.
All right. Okay.
Because we've got
All right.
several questions.
All right.
And in fact, the first question we got from two different people,
All right.
COVID related. Our schools, one person said, not requiring masks, and teachers or educators are being required to use their sick leave if they have to quarantine or isolate due to being exposed at school, where they are required to be in person and in many cases without masks. Is there any way that they can recoup their sick leave that they're using for these purposes?
Well, my answer is there are strength in numbers. There are strength in numbers. And if we act as a collective, come together as a collective and show up to the school board meetings requesting that we, be recouped or reimbursement or given something in exchange for placing our lives on the line to educate our students. So, but that's one of the reasons why we've sued the governor, state school superintendent, Georgia Department of Public Health, and Paulding County Schools, because none of them mandate masks. And we're asking the court to enjoin these entities to require masks.
I would like to add something in, Lisa,
Yes.
to that piece. Just for example, guys, DeKalb County does have something, some guidelines in place. DeKalb County schools guidelines are in place that, and this is something the superintendent put in place based on ODE and GAE's recommendations to try to fix the problem with sick leave, and this may work in some other areas as well. If you have to quarantine based on exposure or you contracted COVID, that the employees are able to request to work remotely if they are able to work. If they are sick and unable to work, then yes, they are using their sick leave. But what's in place now is that if I'm able to work and I have to quarantine because of exposure or contraction of COVID, then I can request to work remotely, and the administrators have to find them something to do.
And I will also point out with that, and again, this is something you're going to want to work, you're going to have to work through your local, because every school district is going to have something different. They can use their American Rescue Plan funds for leave for COVID. The FFRCA or FFCRA leave that we originally had, that had the 2 weeks, that expired in December of 2020, but they can use the American Rescue Plan funds, but your local is going to have to go work with the board, work with the superintendent to get them to do that. Mike, you mentioned our lawsuit against the governor and Paulding and that situation. The question was asked, what are we asking for in the Fulton County lawsuit dealing with COVID?
So our Fulton, how to explain this? So the school district required teachers that wanted to bring their child to work with them because they couldn't find childcare, for example, during this pandemic. They had no place to go, but to bring them to work with them. They made a term and condition of these teachers to sign a waiver of the individual members' rights, but more extraordinarily, of disabled children's rights. It's the most overbroad, audacious move to limit liability that I think I've seen a school district do. And so all we're asking the court to do is to rescind Fulton County's waiver mandate. Our educators are being harmed. They're having their rights completely stripped and torn away from them simply because they don't have childcare. We're in a pandemic and they have no place to go. And our first plaintiff, a disabled child, ended up receiving special education services in his father's pickup truck, because the member said, okay, well, I won't bring my kid to school. So their son ended up going back and forth to the father's place of employment, which is a auto mechanics garage. And so the kid was receiving his public education in the father's pickup truck. Well, that's unconscionable, and Fulton County deserves a lawsuit. And we have recently had to refile that particular case because in the hearing that we had in November, the judge was saying, well, the member hadn't suffered an actual injury because in that case she did not sign the waiver. We had advised her, don't sign it, and we offered an alternative waiver, a much more narrow waiver. But we have another member who signed the waiver, signing away all her rights and her disabled child's rights, which should demonstrate to any court that this particular teacher in Fulton County has been harmed. She signed the waiver, an illegal waiver, as a term and condition of employment. So that's why we went to court in Fulton County. We just can't stand on the sidelines while school district asks you to return to work during a pandemic and ask you to sign a waiver, not just of your rights, but your disabled children's rights.
Someone asked if the district have American Rescue Plan funds that they are not spending. All of our districts have American Rescue Plan funds because they are not required to use all of those funds until September of 2024. So their plans all include multi-year disbursements of those funds. And again, we have to work on the local level to get that plan to include the sick leave if that's what we need. Then another one, someone asked about vaccine mandates for employees and students. And I don't know if there's a legal answer to that. I will tell you that that is a issue that is being addressed in the state legislature right now. In fact, a bill was introduced yesterday that said no employer in the state could require their employees, and no school system could require students to have any vaccination. So that's something we will be dealing with through the legislature this year. And I'm going to say this next one, this is something we're advocating in the legislature. How do we eliminate the waivers to compel the local board not to apply for them? The local boards made the decisions in 2015, whether they were going to be a waiver district or a charter district. They no longer have to apply for the waivers, they have them. We have to get the legislature to pull them back or get the board to remove those waivers. And again, that is going to be something that we truly have to work with the communities to do, because the boards and the systems like them. The question was asked, they expire this year or have to be renewed? No, actually they were supposed to be renewed this year, but the Department of Education has indicated that they are automatically renewing all the waiver systems for all school systems that have the waivers and all the charters for the charter systems. So again, this is a legislative that we are going to have to fight and win at the legislature. And as Mike says, who we elect matters. Taya, someone asked, since employees, and this, I'm thinking this is a specific question, no longer provide input, how are administrators evaluated?
You have leader keys under the state law. So the evaluators, the evaluation would come under leader keys. If you're asking how do the staff evaluate administrators, districts, each district may have a different system. I will say that I can speak for DeKalb because those are the members I represent. They used to have what was called a PALS kind of survey where the employees could evaluate the administrator in the building. They removed that, but the district is looking to bring back some type of system to do that. Outside of that, the only evaluation for administrators is leader keys.
Someone just asked, is there verbiage or statement GAE has that would help us lobby our districts for the American Rescue Plan funds? There is, and I would say that that is one thing that all of your local presidents received all of that information actually at this point last year. So if your local president does not have that, if you send me an email at lisa.morgan@gae.org, and I'll put that in the chat, we will get that. Mike, never heard of this before. The person said they signed a confidentiality clause. And how long does that last?
I'd like to know more about confidentiality clause. The only time I've really seen, and I don't think it's legal, is a confidentiality clause in a settlement as a result of a lawsuit, where in order to settle a lawsuit, there'll be a provision in there that the terms of the settlement are confidential. Okay, I can live with that, but that doesn't prevent anybody from requesting a copy of that settlement agreement under the Open Records Act. That's public. So I don't know. I would need a little more context to understand the question. Anybody who's asking that, shoot me an email or call me, please. Yeah.
All right. And Taya, I know you had some advice for all of us as educators, some best practices. If you will share that with us now.
Number one, if you guys have any issues or concerns, please contact your UniServe director immediately. Don't try to guess what to do. Contact us, because time is of the essence. We want to get in front of it and not behind it. Do not resign. If you are asked to resign, contact GAE. Do not resign without getting some advice. I'm not saying resignation is always bad, but you do not want to voluntarily resign if something is going on. Talk to us first, so that way we can make sure that you go through the correct process to deal with that situation, or even resignation if that's your choice. In addition, documentation is very important. Document in writing. My advice would be to try to stay factual, take emotions out, so that way, if anyone reading this at the district level, superintendent, HR, they don't have to sift through the emotional parts of this or narratives. They can go straight to the facts. In addition to not resigning and documentation, you also want to make sure that you comply and grieve later. If you've given a directive to come into a meeting with the principal, you should comply, grieve later. If you have time to contact the GAE UniServe director, do so. If you don't, they come to you, you have 2 minutes to get to a meeting, you should comply. Take very good notes, thorough notes, and make sure you contact us immediately after if you can. Also, you can work with the UniServe director to submit a summary of conference or of the meeting, so that we can make sure that it is document what was stated to you, what the expectations are, and what's to move forward. If you're asked to sign a document, in most cases, your signature signifies that you are in receipt or receiving the document. Make sure you read it thoroughly. If you have any questions about the document, request that you have some time, request from your administrators that you have some time to review it and get back to them. If they are adamant that you need to sign it right away, you could affix your signature and state underneath it that you are signing it under duress, that you will attach a rebuttal or submit a statement as well. And it's very important when you receive letters, whether it's a letter of direction or any other type of notice of deficiency, if you refuse it and you don't get a copy of it, it's very difficult for us to know how to respond. We need as much information as possible. So it is okay if you're asked to go into a meeting to ask what is the nature of the meeting. You may not get the response you're looking for, but it is okay to request that information so that you can be prepared. Contact your UD. I will say that. Contact us immediately as soon as you think there may be something going on, so that we can look into the situation. Review policy And also your school handbook policies. I think Mike covered that earlier, and where you can find your policies. They should be on the school district's website. You really want to focus on personnel policies. That will give you a lot of information, and also your school handbook. Anything else I may be leaving out, Mike, Lisa?
Mike, I'm going to ask the question, and so there's a couple more questions, and then I have a question I want you to answer. Somebody asked about their system changing from charter. Your local school board would have to petition the state board to do that. And
Correct.
again, that's going to be, you're going to have to deal with your community.
Mhm.
We have a couple of people that asked about things that happened last year and they resigned. Is there any way we can help them with something previous?
Well, I mean, when you resign, you know, unfortunately, you do waive many of your rights, and without knowing specific facts, you know, under the circumstances surrounding the resignation, is there some type of claim that might be viable? But generally speaking, once you resign, you've put yourself in a deep hole. It's much, as Taya was saying, it's much better if you're being asked to resign, contact us first, and we'll be able to assess things. And if sometimes the best thing we can do is have a graceful resignation, or a resignation that is not gonna, you know, follow you around the rest of your career. I mean, we need to slow things down. I think it's one of the more important things we've said. When you're in trouble, we need to slow down and tell our members, don't panic. Call the UNISERV director. Taya was very good at explaining things that very calm manner, and that's our job. Our members call us and they're frazzled, they're in a panic, they don't know what they do, they've never been in this situation before, but that's why they call us, that's why you join. So, you know, help get the word out. Don't resign, call the UNISERV director, and we'll get that train off the track so we can assess what it is we're dealing with. And I mean, I hope I addressed the questions about resigning last year, but I mean, if you're a member, again, feel free to shoot me an email or call me, you know, happy to, you know, get with you on the specific circumstances.
Okay, I put the link in the chat to the map that shows the whole state of Georgia, your UNISERV director, and their email and office phone number. So everybody open the chat and find that. Mike, we had one more question before my question. If someone has an accommodation for a certain size classroom because they are wheelchair bound, can the district waive that accommodation?
If I'm in a wheelchair and I'm seeking an accommodation due to mobility issues,
Mhm.
can they tell me not to use my wheelchair? Is that what I'm hearing?
Right. Can they put you in a smaller classroom?
So you don't have to use a wheelchair?
No.
It-
So you cannot maneuver your wheelchair.
Oh, no, that is contrary to an accommodation. Yeah, no, no,
So, and that person should contact their UNISERV director because they can help them deal with that.
that's right. Yeah. Well, thanks for
Okay.
the question. That's terrible, but
Okay, so Taya said if you're called into that meeting, you're said, no, you can't talk to somebody. No, you can't. You have to come right now. Can I record that meeting, Mike?
well, the question is, do I have to tell the other person that I'm recording it? And in Georgia, you do not.
Mhm.
So if I'm being called into a meeting with my principal and I've got my cell phone with me, you can download a recording app or get some app and just turn it on, and you don't have to tell the other party to the conversation that they're being recorded. That's legal in Georgia. We're called a one-party consent state. As long as I consent to the tape recording, that's legal. And there may be school districts out there that have a no tape recording, surreptitious recording policy. I'm not aware of it, but we've advised members. How many times a day did you advise a member today, Ty, to tape record? I mean,
At least once today. And I will tell you that my recommendation to members is that if that's what you want to do, you choose to record the meeting, don't disclose it. Do not share it with do not tell anyone, not your next door neighbor, that I went in and I recorded the meeting, because it may get out. And then the next time you're in the meeting with the administrator, they may say, are you recording this? Are you recording the meeting? And you may not be able to get the results you're looking for, an authentic, meeting with the administrator. And they may ask you not to at that point. They may ask you not to.
I agree. Don't disclose it even to somebody you think is very close to you on staff. Just keep it to yourself. They have proved very useful, I will say, in certain lawsuits that we've had. The famous one I'm thinking of is against Gwinnett County Schools a number of years ago, when a bus driver was retaliated against for her association organizing activities in Gwinnett County. And she came to us explaining what she was going through. And the people in the transportation department, the managers, were just bashing GAE, and she tape recorded them, and we used it as leverage, but she didn't go around telling everybody that's what she's doing.
So I'll say, tell your UniServe director you recorded it. And if you get to the point you have an attorney, tell the attorney you recorded it. They're not going to tell anybody else. Okay. So I think we've answered everybody's questions. Mike and Ty, thank you so much for all the great information this evening. And thank you to our members who have joined us. And you all have a wonderful rest of your evening. Good night, everyone.